What if I told you that some of the biggest gun control rulings in the country right now are resting on a law that never actually existed? Not a law that was misread, not a law that was stretched a little too far, a law that, as far as anyone can tell, was never passed by anyone anywhere, ever. And yet, it's sitting in federal appellate opinions right now, being used to justify banning where you can carry a firearm in entire states. Stick with me, because once you see how this happened, you're going to understand exactly why so much of the sensitive places doctrine feels like it's built on sand. Let's get into it. Back in 2022, the Supreme Court handed down a case called Bruin, and it completely rewrote the rulebook for Second Amendment litigation. Before Bruin, courts were allowed to weigh the government's interest in public safety against the burden on gun owners, which in practice meant almost any restriction could survive if a judge decided it served a good enough purpose. Bruin threw that balancing test out. Now, if the government wants to restrict how, where, or whether you carry a firearm, it has to point to a real historical tradition of similar regulation from the era the Constitution and its amendments were written and ratified, not modern policy preferences, not what a state legislature thinks is reasonable today, actual historical practice. That single change set off a scramble. Gun control advocates knew that if they couldn't find founding era or Reconstruction era laws that looked like their modern restrictions, those restrictions were going to fall in court. So attorneys general, city lawyers, and academic allies went digging through old statute books looking for anything that could pass as a historical twin to their modern gun-free zones. Courthouses, subways, parks, hospitals, stadiums, you name it. If a state could show that similar places were historically off limits to armed citizens, the modern version of that rule had a fighting chance of surviving a court challenge. And this is where things start to get messy, because the appetite for finding a historical match was so strong that some courts stopped checking their sources carefully. One of the sources that kept turning up was a private legal reference book from 1792, written by a French-born lawyer named François-Xavier Martin, titled A Collection of the Statutes of the Parliament of England in Force in the State of North Carolina. Now, right there in the title, you can already spot the problem. This was a private compilation. It was not a legislative act. Nobody in the North Carolina General Assembly voted on it, debated it, or signed it into law. It was one lawyer's personal project, essentially a study guide for practicing attorneys. And it happened to include Old English statutes that Martin believed were still relevant in the state. One of those Old English statutes was the Statute of Northampton from 1328, a medieval law that restricted people from going armed in public gatherings like fairs and markets. This statute is genuinely important to Second Amendment history because a huge amount of English and early American weapons law traces its lineage back to it. But here's the catch. Just because a private lawyer included a summary of an Old English law in his personal notebook doesn't mean that law was ever adopted, reenacted, or enforced as actual North Carolina statute. And yet somehow that's exactly how it started getting treated in court. The Duke Center for Firearms Law, a database that judges and clerks across the country lean on heavily when they need historical analogs, listed Martin's private compilation under a citation that made it look like an actual piece of North Carolina legislation, complete with a chapter number. Judges doing research under serious time pressure pulled that citation, saw what looked like an official legal reference, and cited it as though founding-era North Carolina had a real law on the books banning people from going armed in public. That's the seed of the whole problem, and it grew fast. Credit for catching this goes to Stephen Halbrook, one of the most respected Second Amendment scholars in the country, who published a detailed law review article laying out exactly how this fake citation made its way into the federal court system and what it actually says once you go back to the real historical record. His findings are, frankly, a pretty big deal for anyone following gun rights litigation, because they don't just question one court's reasoning, they pull the foundation out from under multiple circuit court rulings at once. The first major domino was the Second Circuit's decision in Antoniuk versus James, a case challenging New York's sweeping post-Bruin restrictions on where concealed carry permit holders could legally carry their firearms. New York's law didn't just restrict a few sensitive locations, it restricted dozens of categories of places, effectively making legal public carry the exception rather than the rule for permit holders in large parts of the state. To justify this, the Second Circuit needed historical support showing that broad public carry restrictions were part of the nation's tradition, and Martin's fake citation gave them exactly that. The court cited it as evidence that founding-era North Carolina banned going armed in public, period, and used that conclusion to help uphold New York's law. But when you go back to the actual North Carolina statute, the real one, not Martin's private notes, the story looks completely different. There was a genuine North Carolina law from 1741, reenacted in 1791, and it stayed on the books in various forms through at least 1855. That law directed constables to arrest people who ride or go armed offensively. Notice that word, offensively. That single word changes everything about how the law worked because it means merely carrying a firearm was never the crime. The crime was carrying a weapon in a manner designed to terrify or menace the public. Simply having a gun on you, walking around, going about your business armed was not illegal under this law. The North Carolina Supreme Court confirmed exactly this interpretation in an 1843 case called State versus Huntley, and that reading has been reaffirmed by courts as recently as 2024. That distinction between banning armed carry outright and banning only carry meant to terrorize others is arguably the entire ballgame under Bruin's framework. A historical tradition of punishing people who brandish weapons to scare their neighbors is a completely different tradition from banning law-abiding citizens from carrying firearms in public spaces altogether. One supports narrow, conduct-based restrictions. The other supports the kind of sweeping, location-based bans that New York, New Jersey, and California have all tried to implement since Bruin came down. And the damage didn't stop with New York. Once the Second Circuit's Antoniuk decision was out there, the Third Circuit picked it up and leaned on it in a case called Coons versus Attorney General of New Jersey, extending the same flawed logic to uphold New Jersey's own expansive list of gun-free sensitive locations. The Ninth Circuit then took its turn with a case called Wolford versus Lopez, challenging California's law. Interestingly, the Ninth Circuit actually acknowledged that Bruin had rejected the idea that North Carolina had this kind of place-based restriction. They saw through at least part of the problem, but instead of striking down California's law for lack of historical support, they upheld it anyway on separate reasoning, meaning the outcome stayed the same even after the shaky foundation was called into question. Perhaps the most striking detail in all of this is that the fake citation didn't stay confined to lower courts. Justice Breyer himself cited Martin's private compilation in his dissent in the original Bruin decision, treating it as evidence that North Carolina had enacted a law drawing on the language of the Statute of Northampton, which raises an obvious question that apparently nobody stopped to ask at the time. Why would a brand new American state, one that had just fought a war to throw off a king, turn around and adopt a medieval English statute that existed to protect royal authority? Nobody flagged it, nobody checked. It just kept getting repeated case after case, brief after brief, until it became treated as settled historical fact. So where does this leave things right now? The Third Circuit has already granted rehearing in the Coons case, which vacates the original panel's decision and sends the whole thing back for the full court to reconsider. That means every argument gets made again, this time with Halbrook's findings sitting right there in the record for judges to grapple with. Meanwhile, over in the Second Circuit, a separate case called Frey versus City of New York has already seen one panel concede that Bruin undermines the reasoning used in the original Antoniuk decision, even though other parts of New York's restrictions have still been allowed to stand in the meantime. Here's why all of this actually matters beyond the legal weeds. Federal circuit courts sit just one level below the Supreme Court, and the Supreme Court only takes a small fraction of the cases it's asked to review, often cited around 1 to 2%. That means for the overwhelming majority of gun owners living under a particular circuit's rulings, whatever that circuit decides is effectively the final word. Not because those judges are infallible, but because there's realistically nowhere else to appeal to. When an entire legal framework used to justify restricting where millions of law-abiding permit holders can carry a firearm turns out to be built on a citation to a law that was never actually passed, that's not a minor technical footnote. That's a foundational problem for every single ruling that leaned on it. And that raises the harder question. How many people, how many judges, how many state officials pushing these restrictions are even going to hear about this? Legal citation errors don't usually make headlines. They get buried in law review articles and appendices that almost nobody outside the legal profession will ever read, which means it's on people who care about this issue to actually spread the word, to make noise about it, to make sure state attorneys general and courts can't just quietly keep citing something that's already been thoroughly debunked by one of the country's leading Second Amendment scholars. This is just one example, one case where a fake citation got caught, documented, and published for anyone willing to look. The real question worth sitting with is how many others like it are still sitting undiscovered in the case law, quietly propping up restrictions that would never survive if courts were actually held to the historical standard Bruin demands. If you found this as unsettling as I did, let me know your thoughts in the comments below and share this around because more people need to know when the history being used to justify restricting their rights turns out not to be history at all. I want to leave you today with a quote from Frederick Douglass, delivered in an 1849 address to the Rochester Ladies Anti-Slavery Society, where he said that it is the first duty of government to protect the rights of those who are governed. Not to hand out privileges, not to decide which rights are convenient, to protect them. That's it for this one. Thanks for watching, and I'll see you in the next video.